this cruel world, children get exploited daily. The police around the globe have their hands full with these perpetrators, and they do not belong in society. Palaver stands 200% for justice and will always do. However, does that mean every person who watches pornography is now breaking the law? What is child pornography? Child pornography, also called CP, child sexual abuse material, some child porn, or kiddie porn, is pornography that unlawfully exploits children for sexual stimulation. It may be produced with direct involvement or sexual assault, also known as child sexual abuse images, or simulated child pornography. Child pornography may use a variety of mediums, including writings, magazines, photos, sculpture, drawing, painting, animation, sound recording, film, video, and video games. Child pornography is illegal and censored in most jurisdictions in the world. However, it is known that there is an enormous difference between pornography and child pornography. Pornography is not unlawful. Tens of millions of people use pornography for personal reasons. To an extent, it is even a legal industry to work in. How do you know you are not breaking the law by using unlawful pornography with potentially viewing child pornography? It is known that here is legislation which is in Chapter 110, Sexual Exploitation and Other Abuse of Children. 18 U.S. Code Section 2257, Record Keeping Requirements. You will find that notice on every legit website, or sex-related business. Does this only apply in the United States? No. It guarantees that all people used or displayed on images or videos are 18 years of age and older. That is the benchmark, the standard. And every court in the world cannot go against or have a different opinion about the ages of these people. The accused in this case was charged with the following: Films and Publications Amendment Act 3 of 2009, that he accessed child pornography under Section 24B. Let's discuss Section 24B. The prohibition, offenses and penalties on possession of films, games and publications. 1. Any person who a. unlawfully possesses, b. creates, produces, or in any way contributes to or assists in the creation or production of, c. imports, or in any way takes steps to procure, obtain or access, or in any way knowingly assists in, or facilitates the importation, procurement, obtaining or accessing of, or d. knowingly makes available, exports, broadcasts, or in any way distributes, or causes to be made available, exported, broadcast or distributed, or assists in making available, exporting, broadcasting or distributing, any film, game or publication which contains depictions, descriptions or scenes of child pornography, or which advocates, advertises, encourages or promotes child pornography or the sexual exploitation of children, shall be guilty of an offense. What was the state's evidence for charging the accused of such a horrible crime? Did he access child pornography? To answer that, let's discuss the judgment and evidence.
Court is now in session.
Please note we could not use the trial record in this investigation. We had to make use of the judgment, notes and evidence that was used during the trial. We will now start with the state's evidence. Judgment 6.25 Charles Liu testified, inter alia, as follows. A. He is currently employed by KPMG, and at the time of the investigation was employed by Custom-Made IT Solutions. He is a qualified NCASE certified examiner, NC, which is an international certification. In addition, he holds a diploma in criminal and forensic investigation from the University of Johannesburg. B. He conducted investigations on electronic devices that were handed to him, and formulated a report of his findings, vide Kempton Park Cas 51/09/2013. C. He confirmed that the integrity of the devices was properly maintained from the time that he received it from the investigating officer until it was returned. Further, that he has the documentary proof of the chain evidence in respect of the handling of the exhibits. D. The process involves the investigated media to be connected to a device that can only read the contents, and not write to the electronic device. A bit file image is created, and the original drive is put back into storage with a unique serial number being allocated to such device. The new bit file image is used for analysis and purposes of investigation. There is no chance of the original being contaminated or changed during this process. E. He identified the evidence inventory report, acquisition report, examination report, 4x Appendix AD and 2x DVD set with reporting documents and export files. The report was handed in as Exhibit Z. F. He stated that he found pornographic images on the various media, inter alia, 360, 360, multimedia/video files containing sexually explicit material, page 7, paragraph 16. He referred to paragraph 18 and stated that he found one nude image of the accused and a number of semi-nude images of young models, teens to early 20s, and images of nude adults. At page 10, paragraph 31, he stated that the recovered picture and/or multimedia file content seems to contain nude and/or semi-nude content of more mature teenagers, possible age group 18 to 20 years old, and/or early 20s. G. In addition, he stated that his investigations also revealed that, inter alia, the following websites containing pornographic material were accessed.
Warning: these websites are pornographic and should not be viewed by children. These are also the same website the state claimed to be child pornography websites. And it was this evidence the court accepted to convict the accused. Our investigation shows that not one of the following websites has any underage person, or child, or a depiction of a child in the images or videos. We also looked at whether these sites were legit websites. They all fall under Section 18, as mentioned. Additionally, these websites do not contain child pornography.
The state charged the accused that on the following dates he willingly and unlawfully accessed child pornography. March 2, 2011, galleries. Tryteens.com, no child pornography found. March 4, 2011, video. Teensexmoves.com, no child pornography found. March 5, 2011, video. Teensexmania.com, no child pornography found. March 8, 2011, my18teens.com, casualteensex.com, freenastyangels.com, galleriesteenloveblacks.com, wildthumbs.com, no child pornography found. February 14, 2012, teendreams.com. March 12, 2012, teenporntube.com. The following was only Google searches: imagesearchconduit.com, sex and citi, teen and pussy, teen plus porn, no child pornography found. September 17, 2012, teens video sex source, images 2, youngpornvideos.com, images 3, youngpornvideos.com, no child pornography found. December 26, 2012, Google search, Babylon.com/teens plus sex plus video, no child pornography found. H. He did not tamper with any of the information that was on the devices, and all the items on the delivery note were handed to Banks at the end of the investigation. That in essence concluded the evidence of the 25th witness, Lou. We will now address the defense evidence. SS. He denied that the iPad had contained pornographic images and that he had never seen any of the images prior to receiving the contents of the police docket. He stated that those images were placed on the iPad ex post facto, after the equipment was confiscated from him. He was of the view that Banks and Longervelt had placed the pornographic images on his iPad. He does not trust the investigating officer and relied upon her interview with Carte Blanche, wherein she stated that she will ensure that she puts the accused behind bars. Further, that he does not trust Carte Blanche as they could also tamper with the evidence.
Palaver notice. The iPad mentioned here in the judgment is irrelevant to the websites and web links mentioned in the state's evidence. The accused was found not guilty on all charges related to his iPad. We do not see why this was relevant to mention on these 8 counts.
Judgment Point 52. I have carefully appraised the documentary and viva voce evidence in respect of counts 31 to 38, and it is clear that the images on the various media fall within the definition of pornography, and the documentary evidence clearly shows that these were accessed by the media that was confiscated from the accused. The witnesses in this regard have given their evidence in a clear, uncontradicted and satisfactory manner. I accordingly reject the version of the accused in this regard.
Palaver notice. We agree with the court, be it as it may, however. The court made it clear in his judgment that it is pornography. The accused never disputed the content or pornography, however. Therefore, the accused was and cannot be charged for watching, using, or having pornography on his devices. It is not against the law. It is further impotent to note that he was not charged for accessing pornography. He was charged for accessing child pornography. The court did not apply the law correctly and gave the accused 64 years of imprisonment on something lawful. The charge reads: Count 31, accessing child pornography. Count 32, accessing child pornography. Count 33, accessing child pornography. Count 34, accessing child pornography. Count 35, accessing child pornography. Count 36, accessing child pornography. Count 37, accessing child pornography. Count 38, accessing child pornography. There is not one charge for accessing pornography, and there can't be such a charge as pornography is legal.
Notes, accused. There is no law to say a person are not allowed pornography. There is no criminal element to these charges as set out, yet the judge made a massive mistake by finding me guilty in 8 counts of accessing child pornography, which clearly was not proved by the state. Even if this were my pornography, which it was not, the hard drive belonged to a Jocko. According to the state evidence report, it would not constitute a law being broken. This is because the state failed to prove child pornography. Yet the judge did not care if I was really guilty or not. He was only interested in establishing to the media and the public that I am a terrible person irrespective of the evidence in front of him. All the links and websites related to those searches clearly show no child pornography. Lou himself testified that there are no children on their websites. Read on page 10, paragraph 31, he stated that the recovered picture and/or multimedia file content seems to contain nude and/or semi-nude content of more mature teenagers, possible age group 18 to 20 years old, and/or early 20s. This was images related to these websites, in the links and searches found.
Palaver's conclusion. We assessed this evidence with much caution, and we have not found any traces of child pornography, nor did we find any pornography implicating that it could look like pornography. We do not understand how the court could conclude that the accused is guilty of accessing child pornography. On the lowest of the highest standard, there is no crime here. Not only did the websites display no traces of any form of child pornography, the site certificates, the custodian certificates, the website's usage policies, or the state's witnesses have implicated the accused. We gave attached all the custodian certificates that was handed into the court as defense evidence, which clearly was not considered by the court. This is a nothing burger. And a disgrace that a sitting judge can get it so wrong. We saw a noticeable trend as we worked through all these charges and convictions. The state advocate and the judge were not fair or interested in facts. We can say with confidence that the state and court went out of their way to create this picture that they are dealing with a serial criminal. The accused stood no fair chance against the court. The court got it wrong with the charges of exposing his children to child pornography in charge 1 and 2, the court got the rape and grooming charges wrong in count 3 and 4, same with every other count. Now we see a court convicting the accused for accessing pornography, which is not unlawful. We have to be open by saying that the South African justice got it wrong. There is no doubt in our mind, should the court have tried him in these charges separately, there would never be a single conviction. We further can say that if the court fairly applied the law, accessed the evidence, and looked at the accused would not be in prison for crimes that does not exist, and crimes he did not commit. Out of all the charges against the accused, these 8 charges were the easiest to assess, and we found no case here. Moreover, these charges were dead in the water before it was even reported, and significantly when the state witness testified and confirmed that David did not access any of these sites, and that there are no children in any of the links, the court should have dismissed these counts. There is no secret that the court had no interest in letting David walk away from this free man. However, the court did not assess the evidence. And as David's counsel said it, the court did not deal with this evidence, and the state did not prove these cases beyond a reasonable doubt. We highly recommend that this acting judge get removed from any other cases, and that the South African Justice Department review all his cases with urgency. How many innocent people is now in prison by the standards of this judge? It is not in the interests of justice to convict innocent people. There is a reason why a court has a sitting judge. They should be always fair, assess the cases on merits and facts. We can with all confidence say that acting Judge Kassim Musa has brought the entire Justice Department in disrepute. And severe legal and corrective actions should be taken against him, even a possible disbar and removal of his law license. If you are a lawyer, advocate, the media, get behind this family and help them to get justice for this failure of a case and unlawful imprisonment.